Hello, I'm Alex Ruck Keene. I'm a barrister at 39 Essex Chambers. And today I've got with me Dr. Mark Taubert, who I'll allow to introduce himself. So over to you, Mark.
Hi, Alex. Thanks for having me on. And I'm a consultant in palliative medicine. I work in Bilindra Cancer Centre and University Hospital of Llandoch in Cardiff. And I know you through Twitter, and I suggested it might be quite interesting to have a conversation, maybe from the clinical side of things to the law side of things, because I think our work very much intersects quite a lot, and you kindly agreed. So I think if you could host this on your podcast, on your blog site, then I'd be very honored. It'd be fantastic. And I've even brought a little tomato timer along to interrupt us rudely when we're mid conversation, so that we don't go over 20 minutes. So I hope that's okay.
It's perfect. And I'm really, thank you, Mark. It was your idea. And I think it is a really good conversation to start and a conversation to have, because I think one of the things that I encounter a lot in my practice as a barrister, I mean, both in court, but then also when I before coronavirus was wandering the country, bothering people, was the fact that doctors and lawyers, we're working in the same zone and we need to be working together, but we don't always quite get what we do, and the kind of myths arise. And you have a myth sometimes perhaps about a lawyer. I might have myths about you. So I think if we can start having these conversations, and if this works, I'd love this to be the first of several. I think it's just really important. Can I start with one question, which is always something which has always really kind of interested me, just as a lawyer, reading about CPR, reading about cardiopulmonary resuscitation, and sort of having the urban myths about it. You're a doctor. Would you want to have CPR yourself?
I mean, I changed my mind a little bit about this quite a bit. So I think as a medical student, I would have said yes, certainly. And then as a junior doctor, I probably would have said no, certainly not. Thank you very much. It's pretty unsuccessful. It's pretty brutal. And now as a sort of father, maybe I'm sort of perhaps thinking more, well, if there was a faint possibility of eking life out a little bit longer, maybe yes, maybe no. It's a tricky one. I haven't got a direct answer for you there, but probably earing towards no. And certainly I haven't got any long-term conditions at the moment. I haven't got any. I'm lucky that I haven't got cancer, and I haven't got anything else that I'm seriously ill with. If it were a situation where I did have, say, a serious cancer which had spread in my body, I would certainly get my GP to fill in a DNACPR form, because it's not something I would want. And I would probably, I've got an ADRT, I've got an advanced decision to refuse treatment in specific circumstances. I might elaborate with a bit more detail on that one as well, depending on what long-term condition or conditions I had. So no direct answer for you there, maybe, but eking towards no, because as a procedure or a set of procedures is pretty unsuccessful. It's pretty brutal. And, as a palliative care doctor, I get the phone calls later on, maybe a year later, sometimes 4 or 5 years later, from relatives saying, why did you allow it to happen? You knew CPR wouldn't be successful. Why didn't we prepare for this when he went into hospital? He had CPR, and it was terrible hours, and it was a horrendous experience. So I look at it from that point of view.
Yeah. Well, why do you, I mean, if I can just see that for a second, why is it, do you think, that CPR's got such a almost kind of mythic status? I mean, certainly it's something that people talk about a lot, and I'm just sort of interested because there's so many other interventions that you could provide as a doctor. Why is it, do you think, CPR is being kind of singled out?
I think it's because of the urgency and the immediacy of it. You get called to a ward, you get fast bleed to a ward, someone has collapsed, is lying on the floor, and you need to make a decision then and there whether you're going to continue and give CPR or not. And I think most of the time doctors, if there's no prior decision or there's no prior kind of conversation that has been had, will eke towards giving full CPR, because, and this might sound insane, but because it's easier. It's easier to fall into your protocols and into your procedures and to do something, and then later you then perhaps, this is very honest now, you perhaps later don't think about the family members or the friends complaining, saying, why didn't you try to do anything? We're going to take you to court maybe, or something like that, because you didn't try and do enough. And perhaps it's just that ease of falling into protocols, rather than saying, hang on guys, what are we doing here? Let's have a discussion about this, and this is a horrendous procedure. We shouldn't give it right now.
Mm-hmm. Yeah. Yes, I mean, I think it's so, I mean, the protocols, but also, I mean, I suppose I should say that there must be there is a very clear presumption in favor of taking steps to secure life. I mean,
Yes.
that's a sort of legal presumption, and it's also it's at the kind of heart of a medical ethic as well, that you need to do this.
Yeah.
And I'm sort of wondering how one can think through, if you from a medical perspective, what one can do to explain to people how these balances, how these decisions could be made better.
Yeah, I mean, it's nearly sort of a sequence of fallacies, and you need to go back to step one in the sequence of fallacies, where a lot of procedures get this sort of mythic status of being something that they're built up to something that they are not. And I've often talked about to students and to others who will listen about the media and how they've maybe built up medical procedures to something that they are not. And so perhaps, a general perception, if I weren't a medic, if I was doing another job, I might think, well, CPR is pretty successful. I saw that footballer collapsing on the pitch. He had, more than 45 minutes worth of CPR, and he's okay now. Or I watched that program House or ER, and every episode there's a CPR case there, and they all come out of it fine. And it's nearly built up to something that it isn't. So I think the education on part of all of us to sort of describe what it is and what it isn't is really important. And then the balancing act between actually saying, well, we can just give default medicines and procedures just like that because they work so fantastically well, that crumbles then in a sense, and you can sort of say, well, actually there's a hell of a lot of harm that procedures can do, and there's a lot of harm that CPR can do as well. And I think that's a really important one to remember for all of us. We need to be humble in the things we give, but also in the things we don't give.
Yeah. I had one other question. We as it were agreed beforehand that we had two questions to ask each other, and I've already started cross-examining you. One other question I did just have, and then as it were, we can put the shoe on the other foot. Is I'm as a lawyer, I engage with doctors in different contexts, and one of the things I'm always sort of struck by is the extent to which I probably know that I don't know something. And the one thing I'd really like, so I'm sort of just about enough that I don't understand all clinical realities. But if there was one thing that you could say to lawyers more generally, including lawyers and judges, because judges come from lawyers, that you'd like them to understand about clinical realities, what would it be?
I've thought about this one, and I think that the thing that comes back to my mind is I suppose it's rare that a lawyer might be in a hospital at 3 o'clock in the morning faced with a very complex decision. But in the cold light of day, in a courtroom, I suppose, it can all seem so much more straightforward, and you should have done this, and you ought to have done this. And I read through some of the court cases, and you kind of sort of see that the presumption is, well, in an irrational state of mind, you should have done this, and you should have taken this decision, and you ought to have done this. And I suppose there are so many aspects of being up at any part of the night and decision making that come into it. You nearly need to draw in who the doctor or the nurse has seen beforehand, how many people they've seen beforehand, the situation, whether they've run to the ward or whether they've walked to the ward, their tiredness levels, and all these other things. And I don't know how you can incorporate that in many ways, but I suppose what I'm trying to say is that it's tricky when you're faced with a situation where you're seeing someone and you're making a decision, and you're asking yourself, should this be done or shouldn't this be done? And then also a decision on should I talk to the patient who's maybe on a spinal board and who's vomiting blood at this moment in time about whether they would want CPR or not want CPR. It's very, very difficult, and it lead me on to my first question to you, actually. But that sort of distinguishing between I'm definitely going to cause distress now by having this conversation. Am I going to do harm? That's one thing that I think is very tricky, especially if you're desperately tired and faced with this absolutely chaotic, horrendous situation. And then the other thing, I suppose, is the decision making in terms of a lot of the time when you stabilize a situation in medicine, a lot of the time actually things are okay and you can stabilize the patient till the next day, and you've got a bit more time to think things through then. But in the nighttime, you're sort of thinking they've just come in and there is a chance that they might deteriorate and die. So, should I talk to them, or should I phone the relatives and tell them that I think it's time to actually make a decision on how far we would go with interventions, or not? And then you're thinking, well, if I phone them and everything is fine tomorrow, maybe they'll complain, or maybe they'll complain a month later to say, Dr. Taubert phoned us up and he gave us the fear of our life, and it was really horrendous, and everything was fine, and the person ended up coming out of hospital and was all okay, but we would have really appreciated not having that 3:30 in the morning telephone call. That was really horrendous, really awful, versus them deteriorating and you haven't made that phone call. Mm-hmm. So that's that's something that I think perhaps some lawyers and some barristers wouldn't give a stuff about. But I think some lawyers and barristers who really care about advanced care planning and the MCA and hospitals and the interface between medicine and the law will somehow manage to incorporate, I suspect.
Yeah, I mean, it's interesting, isn't it? Because it's at one level the law is the law. I mean, well, at all levels, the law is the law. Yeah. And I think I think you've really put your finger on something really challenging, which is, if the law says X, Y, and Z, you shall do this, then you shall do this. And it is challenging sometimes, especially after the event, to then go, well, why didn't you do X, Y, and Z? Especially when X, Y, and Z would have potentially avoided a negative outcome, a bad outcome. Yeah. And actually, bad outcome, I suspect here, you might be identifying both as the person has died, but also actually that the person has lived, but in a very substantially worse state, or a very bad state, as it were. And actually, it turns out that, for instance, the person really, really would not have wanted to have that intervention. Yes. But you've carried it out now, and it's, as it were, you're left with this. And the thing I have to say, it's phenomenally difficult to try not to slip into is that thing of the retrospectoscope. With every single outcome, what the end point is. So yes. What the end point is. Yeah. And at every point where something didn't happen, well, there's the counterfactual. Yeah, that's right. And the thing I always, it's always trying to emphasize to medics, but it's challenging for lawyers and judges to apply, or coroners, for instance, in some circumstances, is especially the Mental Capacity Act is about reasonableness and practicability. And it's that, and what one's supposed to be doing in the after the event situation is say, well, what did Dr. Taubert know at that point? Yeah. What was actually reasonable for him to do? What was actually practicable? Yeah. And that's one of the things I always try and explain when I'm doing, because I do an awful lot of training, and when I'm trying to explain about the Winspear case, which you'll be familiar with, but yes. But not everyone listening might be, which is the one where Carl Winspear was in hospital. Young man, 28-year-old with learning disability. And the question was, in the middle of the night, should I put a do not resuscitate notice on his records? And in fact, he dies not because of a lack of CPR not being carried out, but of something else. But because the courts have previously identified that CPR is such a potentially important intervention, that the medic's saying, well, it's not going to happen. Yeah, that's a potentially huge interference with their Article 8 rights. Yeah. That at that point, the doctor should have said, well, I should be ringing mum. Yeah. But that was there in particular because mum had said, I don't care what time of day or night it is, you should ring me. Yes, yes. And so that was a really important bit of information, which in the kind of, where does this go towards what I do? That was definitely in the, well, you need to be doing it. Yeah.
yeah.
I think that's one of the aspects. But I mean, I have to say that the CPR cases, I mean, the Tracy case and the Winspear case are two where I think there's been it's quite a challenging interface between clinical reality and the law. Because they're very crystalline cases in terms of explaining very clearly, this is what you should be doing.
Yes. Yes.
And Tracy, I mean, did have, because clinical bodies did intervene to try and explain realities, it did come back just from saying, under all circumstances, talk to the patient.
Yes.
And it came just back to say, except if it's going to cause them actual physical or psychiatric harm.
Yes.
And you as a medic, I suspect, well, what threshold am I supposed to be applying here? But I think the bit people don't follow up on is they were saying, if a doctor's explained why they haven't done it, we're going to give you a lot of leeway.
Yeah.
Because if you think about it, judges are human. What they would like from you is an explanation about why I did what I did. Which is why we spend our entire time as lawyers banging on about the fact, could you please explain what you're doing?
Yes. Yeah. Yeah. That's right. And I suppose medical notes sometimes 2 or 3 years later don't explain what was happening on the fringes, was happening on the peripheries, and what you were dealing with otherwise, so the other fallout that you were seeing. If I'm seeing 16 patients in a shift and dealing with 3 or 4 really hard things at that moment in time, then each decision could be questionable. As if this is my only patient, or if I'm only seeing 1 or 2 patients, it's a different matter. But yes, it
is. I mean, obviously, then you run into the interesting aspects of the courts will sometimes say, well, as it were, Dr. Taubert, we don't care.
Yeah.
We don't care because you shouldn't have been in a position where you were taking on more than you were in fact capable of dealing with. Yes. And then you do get into this horrendously complex, which obviously at the moment is particularly complex aspect of, well, I'm extremely stretched. I am extremely stretched. How far do you want me to, me, doctor, to stretch my physical resources? Only, X number of human beings. Yes. There are, Y number of people who need seeing. How am I supposed to kind of cover myself here?
Yes. Alex, I've got the little timer here. I don't know if you can see it. We're nearly at the end of this one. I just wonder if we do a part 1 and part 2. So you've asked me some questions. And I think maybe if people are still interested and not bored to tears of hearing us waxing lyrical about all these terms and terminologies, then maybe they'd be interested in clicking on part 2, where I ask you some questions. Little spoiler, in this one, I'm going to ask you what's harm, and I'm going to ask you what a decision is.
Two rather large questions, but yes, excellent. Well, thank you so much, Mark. We'll see. Let's see how people like this, and if people are interested, then let us know, and we can. I personally think these conversations are so important to have, and especially at a time where it's not possible, as it were, to have the conversations physically, in the sense of being in the same room and thinking. I think having these conversations virtually, well, let's make a silver lining out of the cloud, if possible, and see if these conversations are ones which can be more easily shared with other people. So brilliant. Thank you so much.
Thank you. Cheers.